Good evening, and welcome to Lawyers on the Line, sponsored by the law firm of Falsani, Balmer, Peterson, and Balmer. I'm Bob Falsani, founding partner of that firm, and this evening's moderator. Tonight's topic is estate planning, and you probably know more about that than I do, and these folks are experts. And the idea for planning for late years in life, and how you're going to overcome some of the hurdles of passing on assets and dealing with late in life activity, primary care issues for physicians, and will issues, and some of these other things. So we've got some real experts that do this for a living, and they do it every day, and they know all the answers. So feel free to call in and let us know. So let's start out with kind of a basic question. You know, it's political. The political things in the news are always exciting, and taxes are always exciting. And one of the questions is this: when does an estate tax apply in America? You know, we hear all this talk about how people are not going to do well. And by the way, each of you introduce yourself as we start in that, okay? As you answer a question, go ahead.
Sure. I'm Aaron Bransky, and I'm with the law firm of Andrew Bransky and Poole. Estate taxes, well, they used to be a pretty important part of the work that an estate planning attorney does. Not so much now, because the exemption limit per person for federal is $11.4 million. And I don't know about you, but I don't know many people who have that kind of money. For Minnesota this year, the estate tax exemption is $2.7 million. It jumps up to $3 million next year. So again, that does catch some people. So it's not as big a deal as it used to be.
Okay, you two jump in then and introduce yourselves too, okay?
I'm Terry Trogdon. I'm a partner at the law firm of Beaumere, Trogdon, Orman, Hurd, and Villegas. And one of the things that we always have to keep in mind when we're talking about estate tax is that the percentage is substantial. The limit is very high, but the limit can change in a blink of an eye with any change in legislation. It doubled just a couple of years ago, and we don't know how long it's going to stay where it is.
Now, you're Yvonne Novak.
Yes.
And you have your own firm.
Yes.
Right. Now, we were talking about this number. This is a per person number federally, so the estate has to be this $11 million thing?
Yes.
And if you're married, how much is it?
$22.8 million.
And so have you ever had a client that was worth $22.8 million?
Not yet.
On death or family?
Not in Duluth who come to see us.
Yeah, yeah. I'm just thinking how many people in Duluth as a family are worth $22.8 million dollars.
The problem is that the state estate tax is enough lower that when you add in people's retirement plans and their houses and lake cabins, all of a sudden they're bumping up against that number. So we always have to keep that in mind, and that's $2.7 million.
And does that get doubled if you're married?
No, it does not.
We can use trusts in order to manage that better. And sometimes, especially if there's family businesses that have substantial assets, we really have to encourage people to look at that early enough so that a trust can be put in place before the death of one of the spouses. And there is a way that we can manage that. And because a spouse can inherit any amount from the deceased spouse and not have an estate tax.
Is that in state court, you mean?
Yes, that's in the state of Minnesota.
Okay. So let's kind of get a feel for this in terms of how would you attempt to avoid this state taxation? And first of all, what would it be? Let's say your estate, you were single and you had a $5 million estate and you're dying and you've got some kids left, you know, but you're how much, what kind of money are we talking about?
So on the amounts over 2.7, which is the 1.3 million this year, next year, it's 2.3, next year it would be 2 million. The percentage averages right around 16% of the amount over that exemption amount. So it's a pretty big chunk.
Yeah, that's lots of dough, right?
Right. And the way it can be managed if you're married is that you can have a marital trust. There's all sorts of fancy acronyms and things for these, but you kind of set aside some that can be protected as basically a trust that lives on after the person, and then the spouse can take the rest of the estate and spend like crazy to get down to that lower amount, so they won't have estate tax.
All right. So one of the questions we get very often as lawyers is, what's better, a will, a trust, power of attorney? Could you folks kind of give us an idea of how they all kind of interplay, and what do you use when and how?
Sure. Well, power of attorney, healthcare directive, those are tools used to plan for incapacity. So if someone is incompetent, they're out of it, and somebody needs to make a decision for them for healthcare, then you have this healthcare directive. Some people call them living wills. The will and the trust are something that deal with things generally after death. Now, trust can handle things during life. And the differences between those really have to do with what kind of procedure is used. But they're all tools used to make sure that a person's assets go where they're supposed to go after they've died.
All right, now let's talk about regular folks, okay? Not people with $22 million in their estate. We'd only be talking to an audience of one here in Duluth. So for regular folks, do they need a will?
Well, a will is the document that speaks for you when you can't. So if you want to not follow what the state's estate plan is for you, what's set up by statute, and you want to do some things differently, you need a will or a trust to do that.
And I think another important part about a will to help a family get through a tough situation is naming the personal representative, or the executor is what we used to call them. This is the decision maker for the estate. And sometimes the first fight that the family has is who gets to do that. By making a will and nominating that personal representative, you start to solve that issue right away.
Now, what if somebody's got 2 kids? Do you name them co?
No. And the reason is administratively, if you have co-personal representatives in a probate, they're both going to have to sign everything. The other is you're trying to prevent dispute, not encourage one. And when choosing a personal representative, I think one thing that kind of gets lost is it's not an honor, it is a job. It's a lot of work and it requires certain skills. So keeping that in mind, it's really important to make it a thoughtful decision and not one that you just do because.
You mean not the kid that's the heavy drug user or whatever?
Or just the oldest, yeah.
Yeah,
Right.
whatever. All right. Here's a question, which is if you've got a will and it goes to probate, how long does it last?
Depends. Typical lawyer's answer. It depends on how complex the estate is. But I would say, unless it's what's called a summary proceeding, it's going to last a minimum of probably 4 to 6 months, because those little ads you see in the back of the newspaper that basically are called a notice to creditors, the prudent thing to do is to at least wait until all potential claims are out there. So I would say probably a minimum of 6 months.
And then, so during that time, let's say people would like to get their hands on some of the money.
Yeah.
What happens? I mean, how?
You can.
You can.
Now, once somebody has to be appointed executor first.
Right.
Right. But once that happens, there can be distributions before the whole thing is finished. Absolutely. You want to make sure that you've kept enough money in reserve to pay for bills and taxes and that kind of thing.
All right. And then what's the summary thing?
Well, the summary procedure is where you file saying all of the claims have already been paid, the descendants are already determined, and it's a smaller estate that you use that for.
Okay. What if it's just clean as a whistle, though? I mean, you got these real frugal people, and they pay the bills before they arrive, and
The problem is we're dealing with human beings, and it doesn't matter how clean they set it up, the kids have to all agree, and that's where we run into problems.
so you don't use a summary for something like that.
A summary proceeding is not used very often. It's really, in my opinion, a better thing to do a probate, even if it's simple, because it does cut off the claims of creditors, and that order is issued. You have the 4-month period for creditors to submit their claims, And there's then a priority of payments that's applied. There's a lot of structure to it, and having a regular probate proceeding kind of puts some rules there.
Somebody writes that they have 4 children, a home and a cottage, and how to handle dividing all of that up when they die.
Any way they want, right?
Right. It's a challenge because the cottage, I assume they kind of mean it like a cabin. And
Yeah.
those are some of the toughest things to deal with because people want the cabin to stay as it has been in the family forever. And that doesn't always work when you've got a kid in California and in Massachusetts. And so sometimes the kids, one of them will buy it from the estate. So I think, Terry, your point is a good one. You do it any way you can. Most people...
Boy, we're very helpful to the audience.
Yeah, but typically I would say most parents, in most situations, divide things up equally between the children. It doesn't have to be that way, but that's what most people seem to like.
One thing that can be done that's kind of interesting with a cabin or any piece of property is in a will or in a trust, you can set out a particular procedure for determining the price that one of the potential heirs could purchase it from the estate for, whether it's based on assessed value, plus or minus a percentage. But if you do a will, you can do that, and that's a big advantage.
All right. Now, somebody writes, why use a lawyer? Why not use LegalZoom?
That's how we make money.
Hey, maybe you should explain that one, why LegalZoom is good for lawyers.
Because there's so many errors, and there are so many things that we have to clean up because they weren't done right. And it's always less expensive and easier to prevent a problem than it is to fix one.
The problem with using documents off like LegalZoom is that you don't know that those documents didn't work until it's too late to fix them. When we work on them during your life with a professional, we have a better chance of actually ending up with what you wanted to have happen.
Have you ever had a problem with people in internet wills and all that kind of thing?
Sure.
And what about the execution? I mean,
Yeah.
do they tell you how to, does LegalZoom tell you even how to execute it right?
Not the one I looked at today.
Oh, really? Yeah.
And that was the beneficiary is, well, why didn't they know they didn't do it right? And I said, well, LegalZoom didn't tell them, and it was a LegalZoom will that wasn't executed properly, and so they've got a problem in Minnesota.
Gee, this is kind of interesting me since I do litigation. I might want to sue LegalZoom for malpractice. That'd be kind of fun, wouldn't it?
It would be interesting.
All right. How can I make sure if I die, my home goes to my siblings, not just my spouse? Oh,
boy.
This sounds fun.
Oh,
So maybe this is somebody that's remarried late in life or something, you know.
That's a bit of a challenge because the surviving spouse has certain rights to the homestead. And not to go too deep in the weeds, but basically if the spouse doesn't agree to that ahead of time or after death, that's not going to really work because the spouse has a right to the homestead. It's called a life estate. And so that's going to have to be a conversation between the person who wrote in and their spouse if they really want that to happen.
This kind of brings us to intestate succession. You know, if you don't have a will or anything and you die, who takes, right? And there's a statute for that?
sure.
Okay. So let's say you're married and the kids are all grown up and the wife or the husband dies. Does the wife or husband get the whole estate or do the kids get a piece of the action?
Depends on whose children the children are. So if the children are joint children of the two people, the spouse gets the entire estate. If they have children that are not joint children and the decedent leaves behind children who are not the children of the spouse, those children have certain rights. And one of the things that will determine the rights to the home is the deed itself. So you have the real estate laws intersecting with the intestacy laws to try to determine this. But it matters whether it is an actual descendant or not. So this blended family, the blended family thing we have going on, if someone has a blended family, they certainly need to get legal advice.
All
Things
right.
are going to be more complicated.
Yes, that, I mean, that sounds like it. Can you have an executor from out of state?
Yes.
Yes. Okay. 74 years old, no will. What will happen if he dies with no will? We kind of answered that, the intestate succession then.
Could I add one other thing, and that is one of the problems with the LegalZoom is that LegalZoom doesn't ask the questions. And so let's say somebody has beneficiary designations for a life insurance policy. Those aren't necessarily controlled by a will. In fact, most cases they aren't. And so that question is, what happens may be determined by intestate succession, but it also might be determined by the beneficiary designations they have in effect.
One of the things that we'll see is that a parent will leave all of the assets to the child who's going to be the executor because that child knows what the parent wants. Well, once those assets are left to that child, the child has no obligation unless there's a will saying this is how you have to distribute it. And we see that a lot, and it causes a lot of disputes.
Yeah, and then the spouse of that child might not want to play ball, right?
Correct.
Well, there's instances in which that child cannot give away money. If they're receiving medical assistance or anything with means testing, if they have a bankruptcy situation. So there are instances where that simply can't happen even if they want to do that. If you want somebody to have it, leave it to them.
I have a feeling that the people in the audience, you're going to get 12 calls each tomorrow. But anyway, you've really created a lot of interesting issues. No family left. Is there a legal firm she can hire? Where does the money go? Well, if you don't give it to anybody, does the state get it?
If there are not blood relatives that are close enough. I mean, if you've got a first cousin once removed, or what people might call a second cousin, those people might get it. But there may be people you don't even know under the laws of intestate succession.
So maybe you'd rather give it to the Salvation Army or something. You know?
Right, that's where we'd look at encouraging them to deal with the charity.
When a person dies without a living trust in place, are trusts contestable? Is it the same as a will?
Yes, they can be contested, but the threshold for contesting a trust is a little harder. One of the advantages of trusts is that they don't require the court process in most cases. So if somebody wants to cause trouble and there's a will, all they have to do is write a postcard to the judge and say, I don't like my sister and I don't want her to be executor, and the whole process grinds to a halt. If there's a trust and the person wants to challenge, they've got to hire a lawyer to do it. And sometimes that's more expensive than a postcard. And so it serves as some barrier to troublemakers.
The will does.
A trust does, I think, more than a will.
Is more of a barrier to troublemakers?
Yes, it is.
But then what if you have nefarious activity? Isn't it better to have a will then?
There's advantages and disadvantages to everything.
In either way, in either instance, if you suspect that there's fraud or something going on, you can file a lawsuit. You file it in the probate court division. It's a division of the courts. And if it's a trust, you use the trust code. If it's a probate, we'll use a probate code. And there are then ways that the litigation proceeds. But anyone can file or begin a lawsuit that way in order to get to the root of things and get information. You can't get that basic information that's normally confidential unless you have a suit pending discovery, kind of like what you do with the work you do.
Well, I had a contested trust issue, and it was kind of like a will contest a couple of years ago. And, you know, both sides ended up spending, wheelbarrows worth of money litigating this whole thing, and it would have been a little safer and easier if there'd been a will rather than a trust involved, because the guy's dying, it's his last breath, and somebody hands him a pen and says, change the trust, that kind of thing. And of course, the will, at least you have witnesses and all that kind of thing, right?
You should have witnesses to a trust also.
Yeah. Well, anyway, okay. Do attorneys function as executors?
They can.
Yeah.
Not typical.
Yeah, it's not
typical.
Recommended, but they can.
Like if everybody's out of state or whatever.
Well,
huh?
if there are no family, like the card you were talking about before, if there's no family at all and everything's going to charity, then that would be a reasonable situation for a professional to handle it.
What about power of attorneys or payable on death, those kinds of things? How do they come into play here?
Well, that's where an asset has a beneficiary designated. So it doesn't get distributed according to the will, it gets distributed according to the beneficiary designation. So it's a will substitute.
Now, is it better to have, let's say you had a bank account and you're trying to transfer to somebody on death. Is it better to have it payable on death or have it be a joint bank account?
Payable on death. It's when you have a joint bank account with someone and they're an owner with you, you more or less take on their financial situation with yours. So if they have creditors that are chasing them, they could be looking at that account. There's arguments to be made why it can't be, but why, once again, flirt with trouble when
Yeah.
you can prevent that?
Oh, I can see that happening.
Yeah. It gets messy.
Yeah. The bad boy Johnny is in debt like crazy, and all of a sudden the the execution comes down on the bank account, and it's mommy's money.
That's right.
Can
Okay.
happen.
All right.
The solution to that, by the way, is a two-step process, and that is to have powers of attorney that can be delivered if needed, and then just do a pay on death rather than making someone a joint owner.
Now, we didn't get the question we usually get about 11 times for this program, okay? And that's this: how to avoid, how to retain some of the money when mom's going in the nursing home soon, okay? So what are the rules for that, and what are the tactics for that to save some of the money for the family before mom becomes a ward of the state? What do you do?
There's a lot to be said on that.
Okay.
There's a lot of strategies, and sometimes there's no strategy that can be done because it's too late.
Right.
Simple thing is to make gifts, and there are rules about how far in advance you have to make them if somebody's going to be applying for medical assistance. Some of the planning techniques have to be involve things like, is this person a veteran, looking into other benefit programs? And so it's a tough question to answer just with you do A, B, C, and D, because it truly is individualized. And this is a fairly unstable area of the law. So that what is true 10 years ago probably, or has a greater chance of not being true now. That's why people shouldn't depend on what their neighbors said about what they did in 1998 to deal with that problem.
Does the federal government get involved in
Yes.
that process? Oh, they do?
Absolutely, because it's a federal law that deals with medical assistance. That's the base. There's state law on top of that. And so yes, federal law is very important here.
So,
Because the feds might be involved in paying some of the nursing home charges, huh?
well, what happens really is that the state administers it, but it's derived from federal law, and so there's limitations there. And like there's a 5-year look back for gifting. One of the questions on a medical assistance application is, have you given or have you transferred something for less than value within the last 5 years? Well, that 5-year period is pursuant to federal law. Minnesota's tried to change it, haven't been successful. But
So would Minnesota like to make it longer then?
yes,
I see. Okay, so then it might be 10 years if they had their way then,
they
huh?
tried for 6. They didn't get that yet.
Interesting. I had to ask this question, okay? What is a 529?
That's an educational account that you set up for your children. A grandparent could set it up. Anyone could set it up for a child for their educational expenses, or for a special needs child in a certain circumstance.
Not to be used for bribes or paid someone to take a college entrance exam.
I thought you were going to have some special thing so the women from the movie stars would start hiring you, but I guess not. So we got a lot of press for that. But so let's kind of concretize this a little bit. Okay, so Grampy's got some money, and their grandchild wants to go to Harvard, and so there's a trust set up by the parents, right? Would set it up usually?
It's usually the parents, and it's not really a trust. It's a qualified account,
Right.
similar to a retirement account.
Kind of like in a bank or something then? Or,
There's a custodial institution.
Yeah, and it depends on different states what those are, who the custodian is.
okay. So then the money is gifted. Is there a deduction for the person giving?
It's not exactly a deductions.
No, it's just the money grows
Yes.
Right.
tax-free,
Yeah,
right?
Correct.
right.
The
Okay.
earnings.
That's the
Kind of like an
advantage.
IRA, like you said.
It's like an IRA. Okay. That's all we have time for tonight. And we could have had, 400 more questions, I think. But I want to thank you, guests. And you did a great job. And, we could probably have you back next week, but we're not going to. We'll wait till next year. Thank you.
Thank you.
We want to join us next week, hopefully. And it's a new panel of experts, and it's going to be criminal law. So we might have some very interesting questions next week that touch on national issues even. I'm Bob Falsani, and good night. But I did.
I think that's a good way to do it, actually.
What? Yeah.
Everybody got their own name right.
Yeah, well, that's true. Yeah. Yeah. So,
I think,
yeah.
think that worked better, actually.
Really? Okay. All right. Well, don't hold it against me.
We've had this firm name for 2 months, and I had trouble remembering it.
Is anybody going to go out and have a martini though?